how are supply chain shortages affecting supplier-buyer contracts? Cristina Rodriguez is senior counsel with the law firm of Wolfe Pincavage. Hello, Cristina. How are you?
Hi, Bob. I'm good, thanks.
Thanks so much for being with me today. Are we in fact seeing an increase in contract disputes between suppliers and buyers right now? And if so, why?
Yes, Bob, we've seen an increase in disputes all around, including in supplier-buyer contracts, resulting from all kinds of disruptive events that have occurred over the last couple of years. The primary one that everyone's aware of is COVID, the pandemic, the government restrictions that have been imposed as a result, and even cyber attacks, as well as labor shortages that a lot of suppliers are finding themselves not having enough people to meet the demands.
Mm-hmm. And the main issues, what are the main issues arising? Are the result are like who's at blame for shortages and production disputes and things like that, or what is the big topic and the big beef?
Inability to make contracts, to make their deadlines or their delivery amounts. There have also been disputes regarding frustration of purpose, impossibility, whether they've been able to perform under their contracts. And even with insurance companies, to the extent that some of these companies have had insurance coverage, whether the insurance that they have covers the kind of business disruptions that they're facing.
Yeah, all these talks about what constitutes an act of God and stuff like that is probably a big deal. Any particular industries or types of materials that are especially being affected, or is this pretty much an across the board situation?
It seems to be across the board in the sense that but it also seems to occur in waves. Like for a while, we had not too long ago, but a lot of the construction companies were having a lot of shortages in that area. But it doesn't seem that any realm is immune from these disruptions.
Okay. Well, of course, any of these disputes could lead to years of litigation. Very expensive matter these days, and maybe always has been. What is the best way, in your opinion, to resolve these disputes, if at all possible?
Well, the best way, honestly, is to kind of anticipate them. I mean, I don't think it comes as a surprise to anybody that conflicts are going to arise in any supply chain relationship. I mean, the whole supply chain relationship is built on the tension between supply and demand, profit and loss. So accepting that conflict is going to arise and planning for it. And what I mean by planning for it, I mean preparing a conflict resolution, a mechanism, a process in the contracts to resolve conflicts that are going to arise. And the problem is that a lot of times companies will relegate it to a single arbitration provision, or they might not put a lot of thought into how they're going to resolve disputes that are going to be inevitable. And then you end up having processes that don't really work for you, that aren't as effective at resolving disputes. So really thinking about it ahead before they happen is the best way to resolve them. And then implementing a structure that includes a process for complaints, includes a process for identifying potential areas of problems and how you're going to negotiate them, how you're going to resolve them. If it escalates, if you can't resolve them with a simple negotiation, then maybe you will allow for mediation or conciliation, which are processes that involve like a third party, a neutral third party that might help facilitate your negotiations, might help you think of things that you didn't think of when you two were negotiating. And then at the end, if you can't resolve it, then arbitration provisions are very helpful to avoid litigation.
And of course, better than, I guess, crafting a 300-page contract that attempts to foresee any possible eventuality, like, well, in the event of a container ship blocking the Suez Canal or something like that. It's more the process that should be there in place regardless of what happens, right?
Correct. Yes.
Okay.
Yes.
Now, you say in many cases, the mistake or the problem with a lot of contracts is just a single provision for arbitration. Why is that a problem? How many provisions do you need to allow for arbitration? I mean, and I imagine our assumption of our discussion here is that arbitration is a preferable way to go. That being the case, what kind of provision should you make in a contract that is effective and will lead to a good arbitration process?
Well, and I just to clarify, when I said a single arbitration provision, what I meant is focusing only on arbitration.
I see.
Arbitration is where you want to end up if the dispute can't be resolved. But you want to try to incorporate some pre-arbitration
Mhm.
processes. Maybe it's just having a mediation before arbitration. Maybe it's having a complaint department. It depends on the nature of the business and what your needs are and how large and how many resources you can expend to it. But definitely arbitration is the preferred endpoint for any dispute rather than litigation,
Mhm.
because then that really gives you the ability to frame your arbitration in a single provision. You don't need several provisions for an arbitration. But for example, if you think it through, you can have a simplified provision for if the arbitration involves less than, if it's a small dispute, maybe it's less than $75,000.
Mhm.
You don't want to have a complicated arbitration for a $75,000 dispute that you would have for maybe a $5-10 million dispute. So
I
that's
see.
what I mean. Just think it through and maybe have tiered arbitrations if that's something that makes sense for your particular business.
Help me as a non-lawyer to understand the difference between mediation and arbitration.
Okay, so both are similar in that they fall within this alternative to litigation umbrella. But in a mediation, and both are similar in that they involve having a third party neutral. And what I mean by that is a third party, a person who has no stake. They're not beholden to either party to the contract. They're independent, and they come at this, they come to the dispute just in an attempt to resolve it. Now they do it differently. In mediation, you have a mediator who is there really to facilitate negotiations. They're there to be like a middle person between the
Mhm.
two parties. Maybe emotions are high. Maybe there's something that's serving as an impediment to the parties working out a resolution. Well, a mediator will come in and try to, nudge both parties into finding a workable solution and maybe proposing them if need be. But in a mediation, the parties make the decision whether or not to settle,
I
whether or not
see.
to enter into an agreement. The mediator doesn't. Arbitration is different in that the arbitrator, whether it's a single person or a panel of three, which some arbitrations will have a panel of three or maybe even more if it's a really large case, not recommended, but the panel will make the decision. The panel acts kind of what you would think of as a judge, in the sense that they would, hear both sides, consider the evidence, maybe hear testimony of witnesses if the case calls for it, and then make a decision in the form of what they call an award.
I see. Again, excusing my ignorance of the law, the term binding arbitration, is that redundant or is that a form of arbitration? And is there non-binding arbitration?
Yes.
Okay.
Yes. There are two differences. There's binding and non-binding. And the difference is that, as the name implies, a binding arbitration, the parties agree to be bound by the award, meaning that whatever decision the arbitrator makes, the parties agree to be bound to it. So all the parties have to do is then take it to court and get it entered, and it has the same effect as a judgment issued by a court. A non-binding arbitration, the parties are not bound by it. So what's been happening a lot with non-binding arbitrations is that courts during COVID have actually been sending cases to non-binding arbitration to try to get them resolved, because they haven't been able to have trials because of all the restrictions.
Mm,
So in those cases, an arbitrator will hear it and will make a decision, but the parties aren't stuck with the decision. They can go back to court.
I see. That seems like a terrible potential waste of time to go through all of the complexities of arbitration only to fail at coming to a solution and then having to submit to litigation. But I guess it's not an
Well,
uncommon situation.
it's not uncommon, and there's a benefit to the arbitration is less formal than a trial. In a non-binding setting, it's usually you have an expedited procedure. You don't actually put on a full trial, so you don't have to go through all the rigmaroles of of resolving the case.
I
But
see.
there is a value to having each of the parties see the other side's case and having a third party neutral tell you what they think of your case.
Mhm.
And then that way the parties can be like, okay, well, maybe our case isn't as good as I thought it was. Maybe we should sit down and talk.
I see. It's kind of almost a dry run in a way. Are
In a
there
way.
are there often disputes as to choosing the arbitrator?
Yes. And again, this is one of those things that a well-crafted arbitration provision can help. If there is you typically, when you draft your arbitration provision, you can set certain qualifications or certain limitations for the arbitrator. Like maybe you want an arbitrator who specializes in a certain type of industry or in a certain type of law. If you're a pharmaceutical company, maybe you want somebody with a pharmaceutical background or with a scientific background. You can decide you want an arbitrator that resides in Miami, where I am, or in California, or wherever it is that you want the arbitration to take place. You can decide whether you want the arbitrator to be a lawyer. So you can set out certain characteristics, and based on that, it should make for the selection of an arbitrator more an easier endeavor. But you typically go back and forth. If your arbitration is subject to a certain set of rules, you can select. There's several institutions that govern arbitrations, meaning that they have procedures in place. They can facilitate an arbitration proceeding. So they have mechanisms in place for when the parties can't agree, or they have panels of arbitrators that you can choose from. And I mean, even with the back and forth, you do end up finding some way to resolve that dispute. And what some companies do, is they'll select to have a panel of 3 arbitrators, where each party picks one arbitrator, and then those 2 arbitrators pick the third member.
I see. Okay.
And then that third member ends up being like the chair of the panel.
Mm-hmm. Yeah. Well, at a time when litigation is more expensive than ever, can eat up years and millions of dollars of corporate assets and the like, and at a time when disputes are proliferating based on current situation, it sounds like arbitration certainly is a good way to go. Cristina Rodriguez of Wolfe Pincavage, thank you so much for explaining to us the mechanism, how it works, and why it's important that companies should perhaps pursue that avenue. Thank you very much for being with me today. I really appreciate it.
Thank you for having me, Bob. I appreciate it too.